doing that. All right, we're going to jump right into the next question, or the next panel, excuse me, on Icann and the new GTLD program, an issue that's near and dear to many of our hearts. We have an all-star panel for this topic, and I'm thrilled to introduce them. I'm going to keep their descriptions rather short, but most of you should know them by now, and there are bios in the program. The first person on my right is Jonathan Cohn, Managing Partner at Shapiro Cohn in Canada. He's a former board member of Icann and has been in the mix with Icann policy development for more than a decade. So to his right is Amy Stathis. She's a litigator within Icann. She's an in-house counsel there and again is very well versed in this and works from the inside. So we're getting the voice of a former board member, an IRT member, somebody directly from Icann. To her right, we have Anthony Vancouvering. Anthony is what I'd say a serial entrepreneur. He has had several businesses that he's started up. Most recently, he is the CEO of Minds and Machines, a registry service provider on the internet and applicant for the new GTLDs. They have filed for several applications for new extensions. To his right is Christina Rosette of Covington and Burling. She is a former counsel to the GNSO, which is the standards organization within PDP development organization within the Icann structure, and she is currently the president of the intellectual property constituency within Icann. Fabricio Vieira is the head of trademarks at Time Warner, former IRT member as well, and has been active within Icann for his company and its related companies. And with that, I'm going to turn it over to Jonathan. Thank you.
Thanks, Russ, for that introduction. I'm glad it was short. I was devastated at the Academy Awards, and it wasn't a real tiger. It was, is there a real audience? Well, just because we can't do a seventh inning stretch, but we're in a bit of a hurry, I want to just engage you for a second, as David did. And can you raise your hands if you know what Icann is? Okay, that's good. Like 10 years ago, there would have been nobody. How many of you have been to an Icann meeting? Ooh. How many of you belong to a constituency within Icann? Ooh, okay, that's about 6. How many have followed the new GTLD program? That's pretty good. How many of you care? No, don't answer. All right.
Okay, let's go.
So I'm going to try and give you quickly a little context or background for what's going on, because we have a very good panel, and there'll be some slides, but no case law. There is no case law. And first of all, Icann, a lot of you have heard of it, but most of you haven't participated in it. I gather, how many, just sorry, one more, how many of you been, oh, I asked you that, how many of you been to a meeting? In 1998, when Icann was created by the Secretary of Commerce, there were 2 of its main objectives were to increase competition in the domain name space and promote innovation. And one of the other things was to protect IP rights. These are mantras within the Icann Bible. Right off the bat, people started asking for new GTLDs, almost from its inception. And in 2002-03, towards the end of my term on the board, a group of new TLDs were introduced. They were mostly what are called closed as opposed to open TLDs, and there were only 7, I think, at the time, Info, Biz, and a few others. There was still a lot of pressure from certain communities to get more TLDs, and a debate started that led in 2008 to an announcement that Icann was going to open up the TLD space to an unlimited number of new top-level domains. That debate went on for 3 years. And in 2011, they said they were going to go ahead. It's now 2013, not yet. And we don't know when. And I want to explain to you why. It isn't that there's somebody in Icann isn't doing their job. That's not true. They are. The problem is, or the difficulty is, and that's why the title of this program was Unreconciled Differences or Tension. And that is because the nature of Icann is it's made up of a groups of interest groups in the community that self-identify. There's a business community, there's a non-commercial community, there's a registrar community, a registry community, an at-large community, an ISP community, an intellectual property community, etc. And they are supposed to work together to develop position papers on anything that Icann wants to do, and then compromise and reach some kind of consensus which goes up to the board for action. It just doesn't happen. I'm going to say something I'm going to get shot for, but I have always believed that it just doesn't work. It's not designed to work that way. It was blue skied that way in Washington in 1996 by our magazine and others. It just doesn't work. Some of these groups are irreconcilably opposed to one another and couldn't agree if it was Thursday, and the evidence is clear about that. So what I do think it does is it's an excellent method for having self-identified groups recognize what the issues are in something like new GTLDs, put out their positions, let the other groups comment, critique, argue, whatever it is, and when all of that is done, there is a good amount of information that goes up to an informed board for decision. But that's just heresy. It's not to be said. So that's the background that makes for this tension that's difficult. Right now, just this week, I believe, there was an announcement that one of the rights protection, or tools for rights protection measures in the Trademark Clearinghouse will go live at the end of March. I'm not sure what that means. And the National Arbitration Forum was appointed as the first provider for URS, or rapid takedown services. So it's taken a long time to get where we are, and I'm not sure where we're going to go, and I'm going to leave it to my panelists to bring you more up to date, starting with Amy Zathos, who's an integral part of the management, if you like, at Icann and knows where it's at and is going to give you more details on some of the things that I've said. Amy, yours.
Okay, so just briefly, I'd like to make two admissions first. I am not a trademark lawyer, so I haven't done any surveys. The second is my slides aren't nearly as good as other people's, I'm sure. So please bear with me. They're simple. There's only 10, and I'll go through them very quickly because Jonathan did say quite a bit of what I was going to say in terms of setting up the structure of Icann, but I'll put a few more parameters around it. We're also going to talk briefly just about a little bit more detail on how we got to where we are in terms of the expansion of the top-level domain space, and then spend a little bit of time on the rights protection mechanisms, which everybody else on this panel certainly has a lot of understanding and direct involvement with, development of, and then talk about what's still going on in terms of discussions and what we've committed to as a group after the new GTLD program is put in place. So first of all, what Icann is a multi-stakeholder, private sector-led, bottom-up policy development model. I think this is what Jonathan's saying that he thinks doesn't work. I respectfully disagree, because I think that we do have a program in place that has been hammered out, and yes, lots of compromises have been made by lots of different interests and groups, but I think we are at a point where we have a new GTLD program that is going to be effective and has set up to, as in terms of timing, we are looking at having new GTLDs in the route this year, and I have no doubt that that will happen. So one of the things that Icann does is DNS, or Domain Name System Technical Coordination. We act for the benefit of the global internet, users, and parties involved, not for any one particular group or interest or stakeholder. It is where the policy development involves all interested stakeholders globally. So I know this is going to be a little hard to read, but just to give you a flavor of how the structure is established, we have a lot of input that comes into the board from the entire Icann structure. And what I want to clarify here is that what we're talking about is Icann as the whole community. Because there is Icann, the corporation, there's a nonprofit corporation organized under California law, but Icann, the community, is the group that has made and helped build this new GTLD program. So you'll see over here on the left of the slide are all the groups that get together that have organized themselves to help advise Icann. The folks on the right are the supporting organizations, are the groups who in fact made up of all of these various communities that Jonathan had mentioned that in fact develop policy that Icann, the organization, implements. Briefly, in terms of the expansion of the top-level domain, there was an initial program in 2000 after Icann had been established. As Jonathan had mentioned, that there were 7 new TLDs put into place then. 4 of them were basically open, and 3 of them were what we called, at the time, sponsored top-level domains. There was a large call for additional sponsored top-level domains. So again, at the end of 2003, early 2004, there was a second round of only sponsored top-level domains. And ultimately, that led to an additional 8 top-level domains. Right now, there's a total of 23. Some of them you probably have never heard of, but there's only 18 that are actually in the bailiwick of Icann in terms of generic top-level domains that we have, that the community can develop policy for. In terms of the new GTLD policy development process, in very broad brushstrokes, the policy development process went through 21 months of intensive effort. There's many meetings, many public comment periods, informed by many different working groups. One of them happened to also be a protection of rights group. That group did not come up with any specific recommendations for the new GTLD program, but it did identify 6 various principles under which it should be operated. What we have now today is certainly expanded upon those principles, and very specific protections have been put in place. In terms of the rights protections that do exist now, we've got, before Icann was established, there was no special protections in the domain name system. Now, and having existed for the last 12 years, successfully is the UDRP, or Uniform Domain Name Dispute Resolution Policy. I'm sure many of you, if not all of you, have been involved in a UDRP proceeding in some way or form. And then with the additions of the new GTLD program, I'm sure you're all familiar with most of these, but at the pre-delegation stage is the legal rights objection. Those are coming up. If any are filed, they must be done by the 13th of March. We also have established, and everything from here on out is something that actually was established by the help of some people actually sitting on this panel right here. And I'm sure they'll have many more details to provide. The Trademark Clearinghouse is a repository for trademark data that will help support 2 mandatory protections, both a sunrise process and a mandatory claims notice. We can talk more details later in discussion if you would like. Also a mandatory thick who is, so there's additional information at the registry level so you can understand and find out who the registrants are. URS, which I'm sure you're all very well familiar with, which is a rapid suspension process. And then there's a trademark post-delegation dispute resolution mechanism for if the registries are operating in a systematic fashion in bad faith with respect to a pattern of practice of having infringing names in the registry. As I said, the way that these protections were initially developed was after the program or the policy recommendations were identified and there was an applicant guidebook put out, there was a call for trademark protections, and it was absolutely recognized that there weren't any specific trademark protections. The board asked the community to get together. Christina and Fab were both on this, what we called the IRT, but it was a group of IP experts to identify some specific recommendations that then the community could look at and consider, because without those, it was going to be hard for, such as the protection of rights group could not come up with specific protections, but the IP experts were needed in order to have that in place so that the community can discuss that. There were subsequent many public consultations, and then another multidisciplinary team made up of various members of the Icann community, which included the IP folks and included the members of the non-commercial and other commercial constituencies. Subsequent to those, any revisions that they had suggested, then we have our Governmental Advisory Committee, who also provides significant advice to us, and we must listen to that under our bylaws and consult with them on those recommendations. And then the result is the set of trademark protections that we have today. There are some continuing discussions going on, some additional suggested protections that are currently out for public comment, and those including extending the sunrise period for an additional 30 days, extending the third claims period, which right now is 60 days, into 90 days, adding another claims period, which is a claims 2 period, which would be a voluntary period where the claims period could extend for a longer period of time, including notices for names that have been the subject to adjudications of prior abuse, either through a court proceeding or UDRP. And then finally, which is the intellectual property constituency and the business constituency, had identified an additional suggestion, which was identified as a main priority, which was limited preventative registration. And maybe I'll leave that to Christina to explain a little bit more about what that might be. And then, of course, the possibility of a new policy coming out of the GNSO is always there at any time if they decide to initiate a policy development process that could include additional protections. And finally, just to let everybody know that we have committed both to our Governmental Advisory Committee, we've committed to the entire community, we've committed in writing through an affirmation of commitments we have with the United States government that we will review this program, we will review the protections, we will review all aspects after the new GTLD program first round goes live, to ensure that we identify things that worked well and continue enhancing those, and to identify things that may not have worked very well and to figure out how to fix them, improve them, and ensure that certainly with respect to the protections that are in place, that they are actually working. And if they're not, we're committed to making sure that they do.
Thank you. Anthony?
Thanks, Jonathan. I am struck by the lack of data that has informed this entire debate. And it was interesting to listen to the discussion about surveys earlier. Basically, we don't have a lot of new GTLDs. So everyone has been fighting over stuff based on their reading of the tea leaves. And I look forward to a more empirically based set of arguments as we go forward and these things come up. So I thought it would be useful just to present some data that we actually do have and some actual ways of projecting a few things. I have to go to investors all the time and ask them to give me money, and they say, well, what's going to happen? And they tend not to be interested in arguments about what might be, but they want to see some actual data. So let me show you a few things. These are pretty unrelated, but maybe interesting to you. So there are only a few people in the world who have what we call the Who Was database. Matthew Zook is one of them. He's the guy who provides the information for VeriSign's domain name brief, which comes out occasionally, which shows the size of the growth in the domain name industry. And he did a really good talk in 2007 for the APTLD, which is the Asia Pacific top-level domain group. And they asked him, what drives demand for domain names? And he looked at a bunch of different Asia-Pacific TLDs and their policies and their prices and their procedures and their volumes and so on. And what he came up with based on that was a few things. So first of all, price is not a significant factor in adoption or demand. And I've seen this too if you look at all the South American ccTLDs, you can look at volumes and prices and you'll see there's very little relation. It's a more significant when it comes to smaller players, but I suspect that has to do with domainers who are very price sensitive because they have so many domains. GDP and number of internet users, that's key. IDNs have zero effect. So Icann's made, for a lot of good reasons, a big deal about internationalized domain names, that is to say, names in non-Latin scripts, but we don't see any significant adoption of them. And finally, the key thing I've put in italics here is that domain names are treated by consumers as complementary, not substitutable goods. I know a few TLD operators who tell me that for every registrant in their zones, there are 3 domain names, and we see a lot of that kind of behavior. So we don't really need new people buying domain names to increase the number of domain names. People love to buy them and keep them. So this is just one part of, by the way, all this stuff is either something I did or is in, oh, sorry. Thanks, Christina. Stuff that I did or is publicly available, and if anyone's interested, I'd be happy to send you links or the actual studies. This is something that was done by the Austrian ccTLD, and they looked at the economic impact of their .at top-level domain. And this is just one of the many graphs that I took from their presentation. This looks at the jobs created for every euro spent in different industries. And you see over on the right, there's the domain name side. So this is like one little indication of what a domain name could be. And there's been a lot of argument over the I think you said 21 months, but I look at it as 10 years. About what is are top-level domains any good. So this is a little piece of data, and there's a lot more in that study. I'm going to zip through these. This is something that I present when I talk to investors. So one of the very few correlates we have between new top-level domains and existing ones is where we're talking about geographic top-level domains, because they're very good comparable to ccTLDs, which have been around for a long time. And so what we find in the developed world, at least, is that there's a correlation between population and adoption that goes from about 10 to 20%. So you have New Zealand with about 4 million people and 400,000 domain names. You have Britain with 60 million people and 10 million domain names. Germany, 90 million people, 18 million domain names. The last bit there is just what I show. So we have applied for, with governments for .London and .Miami, .Budapest, .Bayern, and .NRW in Germany. And together those are about 50 million people. So we think with a little bit of advertising and marketing, we can achieve similar things. So that's just gives you a sense of what might be achieved. I'm not saying this will happen. So I did a study in 2010, and I looked at the Fortune 100, and I, oops, thanks very much, Amy. I'm really bad at that. I looked at the Fortune 100 and their top 10 brands. Now, not all of them had 10 brands, but I took the top 10 where they were. And I looked at where their names are registered. It didn't mean that they'd register them. They might have been pirated or cyber squatted or whatever. But basically, 100% are registered in .com. And then it sort of trails down from there. And if you look at what these top-level domains are, you'll see that they basically are in a series that has to do with age and popularity. The older and bigger they are, the more infringements there are more registrations there are. And then, this is another study that I did, and I just sort of invented something called infringements per million. It's not really infringements. It's UDRP cases filed. And you'll see that within an order of magnitude, It's the same in every top-level domain. .com has the most. .mobi is also pretty high, but basically what you see is that in terms of number of UDRP cases filed, it's really about how many names are in the zone. It's not really about the name itself. So I think this should give people in this room a little bit of comfort, because we don't know how much the new GTLD program is going to increase the number of domain names. We think it will be something, it won't be nothing. But I hope that you will find that the number of infringements continues to bear close correlation to the actual number of names that are registered by everyone. Then, by the way, this is a meeting that was held in January. I wasn't there, so I wasn't discussing things I shouldn't have been discussing, but the other guys were talking about this, and they did a poll of what kind of prices they were going to charge in the Geo TLDs. And you can see the numbers there. I wasn't there. The other people in London weren't there. So that London number is completely incorrect, but most of the other people were actually reporting what they were thinking about charging. And you will see that they tend to be significantly higher than the prices that currently pertain in .com and .net and .org. And one of the stated reasons that people do this is because they think it will discourage cyber squatting. It will discourage the easy pickup of domain names for very little carrying cost. You'll also notice a trend to sort of starting high and going lower. What that means and whether this will happen, I don't know. But I thought that might be interesting to the group. You can begin to look at new patterns emerging and new ways of thinking about how these registries are going to work. They tend to think of themselves as running a neighborhood, and so you want to keep the sidewalks clean and the lawns mowed and so on. So that's just a few slides with some data, which, as I said, I hope is how we start to look at questions in the GTLD program going forward. Thank you.
Thank you very much. Now you've heard from a heretic. You've heard from the inside of Icann. You've heard from a man who's a portfolio of domain names for various people. Now we go to the dark side. We go to Christina Rosette, who is a very good trademark attorney and represents a lot of GTLD applicants, and is also, with her other hat, the president of the intellectual property constituency currently, and having to deal with that burden. And finally, but not least, we will go to the fabulous Fabrizio, who is a brand owner, and will give that perspective. So without further ado, Christina, you're on.
Thanks very much. Before, I wanted to talk a little bit about the different hats and how those are manifesting some of the tensions that Jonathan has talked about. But first, as president of the IPC, I'm going to beg, I'm going to grovel. I don't do it often, so please pay attention.
It doesn't.
We really, really, really need your support. We have about 100 members. I would say that easily 90% of the work is done by about 10 to 12 people. And quite frankly, it's just not sustainable. Folks are really stretched very, very thin. The membership application, which you can get to at ipconstituency.org, is relatively straightforward. Membership is not expensive, ranging for most of the folks here probably in the $100 to $200 per year range. The reason we need your support is that there's a lot going on in Icann, and there is a general assumption that silence is acquiescence. For example, if there's a public comment period and there's no comment put in by the IPC, or frankly, this I think applies throughout the whole Icann community, then there's an assumption that a particular group that didn't comment doesn't have a concern or isn't affected or doesn't object. So for example, as of today, there are currently 12 open public comment periods. That's a lot of public comment periods to keep track of. We need people. We need people in working groups. And although there is definitely a significant learning curve, it's really critical. We also need people to come to the Icann meetings. I'm really thrilled to see so many of you have actually gone. Icann doesn't make it easy. They have the meetings 3 times a year in locations that most law firms and corporations view as boondoggle locales. To fully participate in the meeting with travel time, you're looking at 10 days out of the office. So like I said, it's not easy, but if it's ever possible for you to attend in connection with another event, I really encourage you to do so. We've seen most recently in Toronto that when we have new faces participating, they tend to get a better reaction. Quite frankly, I think folks at Icann are sick of seeing me and Fab and Russ and Jonathan. We also need your support once the outcomes of these various processes are complete. It doesn't help us when we've done everything we can with the limited participation that we have to get to an outcome that we think is probably not ideal, but under the circumstances is the best that we can get, and then we are immediately accused of selling the trademark community out. That is not very helpful. So just in short, I really encourage you all, please participate, please join. So with that, I'll switch over to the different hats that I've been wearing. As Jonathan notes, I am advising a number of clients that are applying for new GTLDs. Some are closed brands, others are open generics, others are closed generics. And what I've had to really explain to folks is that Icann is not like any other organization that you have ever encountered in your professional career. And you have to just start from the assumption that it is just this sui generis creature where you have all of these different interest groups trying to come to agreement through a policy development process that, as one commentator in this community has noted, is just a little bit shorter than the term of elephant gestation. And once you get through this process, which takes usually at least a year and sometimes 2, the outcome is not necessarily going to be certain. The contracted parties effectively have a veto within the GNSO, not necessarily structurally, but in effect, which is good if you are going to become one of those contracted parties. But then you end up in a situation with some of the tensions that I'll get to in a minute. As I noted, there's always at least one public comment period. So if you're making a commitment to become a new GTLD registry operator, you are making a commitment. You are not just going to, it's not like throwing spaghetti against the wall. You're going to spend a ridiculous amount of money putting together an application. You're going to pay the application fee. And then from that point forward, you're going to have to always be monitoring what is going on. How are these new contract amendments? For example, what just ended yesterday was a public comment period on new registry contract amendments. And this is a contract that has been in the applicant guidebook in one form or another since, I believe, September of 2008. You've got applicants who have put in applications on that basis, and then there are new amendments with a 21-day public comment period. I don't mean to suggest that I don't necessarily disagree with the substance of some of those amendments, but it's just something that in many corporations, you can't get sign-off on a change to a major contract in 21 days, let alone be in a position to approve it. I would also note, and I think this is the part that is really most difficult for folks to get their minds around, is that there are very few institutional checks and balances within Icann, and more specifically with regard to the participants within the process. And just to kind of give you some examples of what I'm talking about. Fairly regularly, if you are participating in a working group or listening in on a GNSO council call, and anything relating to trademarks comes up, you will hear at least 2 false statements about trademark law during the course of that conversation. There's no one who will correct those false statements, so they tend to take on a life of their own. Both Jonathan and Amy had referred to the IRT, and I think this, to me, is an example that frankly just gets my goat the most, but I think really highlights the problem. During the first Icann meeting after which the report was released, it was challenged very aggressively by the non-commercial users constituency. And one of the leading members in that group, who was very active and very vociferous about how the trademark owners were overreaching and the recommendations were inconsistent with trademark law, and it was to the detriment of users, and we were going to be violating First Amendment rights, and engaged in these types of statements and characterizations for the 10 days of the meeting. Later acknowledged that this person had not actually read the report. There's no one who calls that type of conduct. So it's really important when you're participating that you're keeping your eyes open, and that's why we need folks from this community to participate, so that we have more people who can really pay attention and be in a position to correct inaccuracies or exaggerations. And just kind of segueing now, if I can, to something that Amy pointed out, the limited preventive registration recommendation. And that was something that came out as a consensus recommendation from the intellectual property constituency and the business constituency. And before I get into the details, if I could just have a show of hands of the folks who either participated or participated on behalf of clients in the .XXX Sunrise process. Okay, some of you. So basically what .XXX did is they had a two-phase Sunrise. The first part of it was for participants or members of the adult entertainment industry, because that's what .XXX was intended to be for. And once that period ended, the second period for Sunrise, Sunrise B, was for trademark owners who weren't in that industry. And the whole purpose of that Sunrise B was to allow trademark owners who would meet the criteria to get a registration of brand.XXX and immediately shelve it. They don't want to use it, and they certainly don't want anyone else using it. So this was a really novel idea about how to try from the outset minimize the amount of cyber squatting. And that was effectively what the limited preventive registration proposal was, that there should be this new phase of Sunrise that would allow trademark owners to secure a domain name registration. They would have to otherwise meet all the eligibility requirements, and then they would just frankly shelve it. They would have to agree that they couldn't use it for 5 years to avoid any instance where someone would try and get it and then say, okay, I've changed my mind, now I am going to use it and monetize it. There were some protections in place to discourage folks from engaging in reverse domain name hijacking. And what ended up happening is very quickly a certain portion of the Icann community decided that the limited preventive rights registration proposal was a block. And as soon as you start throwing the word block around in Icann, you might as well just pack it up and go home. And so I think that is kind of a good example of how some of these issues really take on a life of their own, how you do have these unreconciled tensions. Another area where I think we're seeing it is within the registry stakeholder group. Every new GTLD applicant is entitled to become a member of the new TLD applicant group, which within the registry stakeholder group structure are observers. The problem that, at least what I've seen for brand owners who are new GTLD applicants who are trying to participate, is that by and large, the folks who are active within NTAG are the folks that are portfolio applicants, that if they don't have multiple applications, they are going to be operating this as their primary business, which basically means that this is what they do. This is their primary business. So they have their entire business day to pay attention to the hundreds of emails that are going back and forth on the listserv. And so we're seeing a situation where, most recently with some comments on the strawman proposal, that the NTAG stated in their comments that the comments had the support of the entire NTAG, when in fact it didn't. And the reason that the comments didn't reflect that is that they were operating on an opt-out. In other words, you were presumed to support unless you spoke up. And if you didn't happen to be digging through the 200 emails that came in that day on that issue, you wouldn't see them. So I think we are going to see a real tension within Icann as the new GTLDs go forward, as brand owners become contracted parties, trying to figure out exactly where they fit and how that is going to affect Icann itself. Very quickly, to clients that aren't applicants but are going to be registrants, I really just say 3 things. First, don't panic. Even if the clearinghouse is open on the 26th, you don't have to be there waiting at the door. Let someone else be the guinea pig and see how it works. Second, be strategic. You don't have to dump your entire portfolio into the clearinghouse. And frankly, at $150 per registration per year, you'd go through your entire enforcement budget very, very quickly if you did that. So think long and hard about what's going to get you the best bang for your buck. And finally, make sure you're participating. If you're not participating in the process and the system, it makes it a little difficult to complain later that you weren't heard. So with that, I'll turn it over to Fab.
Pat, before you begin, I'm sorry, just when you do it, I wonder if you could deal with the question of you've been very engaged as a brand owner, but a lot of other companies haven't. Maybe you'd just comment on that in your remarks. Thanks. It's all yours.
Okay. So it is very hard to follow these 3 and 4 if you include Jonathan, because they've obviously given you a lot of very, very precise and informed information. So what I'll try to do is give a little bit of context from a brand owner perspective. And to do so, I think I need to make some declarations first, and some would call this confession. Depends on what crowd you're in. Luckily, a lot of trademark attorneys, so you'll be sympathetic to some of my confessions. The first is I'm not a statistician, so I won't be putting up any form of chart or graph. I think to be a statistician, I'd have to know something about numbers, and when prepping for the bar, I was told that if I knew something about numbers, I would be taking becoming a doctor, not an attorney. So here I am as an attorney. The second is that I don't have a crystal ball. I've said this since the beginning, so I can't really say whether what Anthony's saying or what we've heard from Amy or those proponents of the GTLD program are correct or aren't correct. The third is that I am an attorney. And fortunately for this crowd, and maybe not so much outside of this room, I happen to be the flavor of trademark attorney. And as a trademark attorney, I happen to work for one of the companies that collectively, and I have some of my colleagues in the room from Turner and Warner Brothers, collectively we've, I believe, continued to be in the top 5 companies, registration companies. So it means that if you boil that down, we have a lot of trademark registrations as a company, and we continue to file a lot every single year. If you think about all the companies in the United States, if we're in the top 5, that's pretty good. And it's a lot of numbers. So the numbers I can provide when we talk about lack of data is that as a company that has so many trademark registrations, as focused as we are and try to maintain our budgets, et cetera, as a company, we've gone from as high as 60, 70,000 domain names in a portfolio in the past. And that's with us continually pruning, continually divesting companies, et cetera, which at any time can take 10, 20, 30,000 domains with them. We will very quickly come back up. And when we've tried to analyze that data, because we do feel it's a lot of wasted money from us, we've found on average that our portfolios range somewhere in the 93 to 97% defensive, meaning that they're not domain names that we would have otherwise registered. Looking at my Turner colleague here, they've got CNN.com, and they're one of the highest populated sites for news, and so why would they get all kinds of variants? And they do so as a defensive measure. Obviously, we all try to make lemonade out of lemons and redirect and do things like that, but that's a high proportion of domain names that we wouldn't have otherwise registered, maintained, and managed. And so when I hear throughout the years we should take some comfort in certain stats, or we should take some comfort in some of the rules we've put forward, I thought very appropriate finally that I'm in a studio setting that I can actually say this, and it's an image that I've had since easily 2009, recurring in my head every time I'm in one of these sessions or an Icann meeting or not. How many of you have seen Naked Gun 33 1/3? I may be dating myself. And there's that classic scene where the cars are blowing up in the background, and the crowd runs up and says, and the police officer goes, "Nothing to see here," and another car blows up in the background, and the audience goes, "Okay," and they just walk away as though there really was nothing to see there. And I feel like I'm that audience member continually, right? Because I look in the crowd and I see many of you who've been there with me or filed comments or done something and in essence shown concern, the same concern we have, based on the data that we live with for many years and the money we've been investing in this, and we're continually told there's nothing to see here. You should feel comfortable. And I guess we're here for one reason, right? And the reason is because we don't feel comfortable. There's no other way to say that. And what that has equated to many, when we file comments, at least from the Time Warner perspective, has been that people come to us and say, oh, so you want to stop TLDs. You know, and I recall that I don't have a crystal ball. So I'd be really, really dumb to say that I want to stop TLDs. Because if TLDs take off tomorrow, as someone who works within a corporation, and I was the guy raising his hand saying, stop it, my marketing executives will have me thrown out on 58th Street in a heartbeat, right? So I can't say stop it. But what I can say is, based on what I've seen internally, what my colleagues tell me matches or mirrors my experience, we should do things. And in all fairness, with Amy and Icann, we have been doing stuff, right? Whether that stuff will be the right stuff is to be seen, and none of us does have a crystal ball. But you know, I don't think that any of us here really say stop TLDs. I think that that's a knee-jerk response when you don't think that participation or an alternative of working through the model actually gets you anywhere near comfort. And so it's kind of like backing a cat into a corner. They hiss and try to bite and scratch, right? And you know, that's where a lot of brand owners feel that they are. So you know, I heard a lot about whether the bottom-up process works or not, and I think with the limited time, I'll say this to kind of answer Jonathan's question with involvement and why have I been so involved, and why do I think others haven't been as involved. I just finished, and I know some of my colleagues know this, I just finished after, from 2008 till now, at least 3, 4, 5 trips a year based on Icann stuff, and that's a lot of investment. And just finished now writing a 48-page memo to upper management that tries to explain to them why we're doing this, right? And you'd wonder why 48 pages. There's a lot to Icann. You know, if you can get past the understanding the process, then you start to have to understand a new language. And then assuming that you understand the process and understand the language, then you still have to get past the hurdle that that new world doesn't look anything like what we are used to. And what's most disturbing about it is that we're all used to a certain modicum of effort backed by a certain amount of expertise, founded on a certain amount of facts, usually tends to come back with a certain result. But at Icann, that's not the case, because from 2008 to 2013, my colleagues and I have filed numerous comments, participated in numerous groups, you name it. I just finished 2 days with you guys at the Who Is working group, right? And I can promise you that at the end of all these years, the difficulty in why other people don't participate is that I end up having to say the same question month after month, year after year, which is, how do we measure this? And at best, I can measure millimeters of progress, at least what we consider progress or change. So that's a difficult thing for most companies to get behind or get their management behind. And I think that's why we don't see the participation. But in wrapping up, I will say that, to Christina's point, there are very few people carrying the weight for many. And that's just a matter of process and, you know, how things work out in life. But I will say this, whether the bottom-up process works or not, one thing is absolutely guaranteed. Like many systems, it is a pay-to-play system. And if you're not paying in and participating, you really shouldn't be coming out and complaining about it. It would be like me sitting on the couch every time the lotto winner comes up and saying, dude, I never win. Well, it's because I never buy a lotto ticket, right? I can't possibly win. And so the only way that we can try to effectuate some change here, whether it's measured in millimeters, yards, whatever, is to actually try to do something. And that can be through comment, that could be through participation in groups, that could be through meetings with Anthony and Amy, what have you. But I think that we all need to give it at least a fair shake. If for nothing else, if we are going to complain later, we can at least say we tried.
Thank you. I think I'm going to get a couple of comments and questions up here, and then I'll open it up to the floor because we're gaining back a lot of time, which is good. You're seeing a micro. I just want to make one quick comment. And that is, what you're seeing here is 4 or 5 different points of view. Never lose sight of the fact that we're actually pretty good in this group. There are a number of other groups whose points of view are farther away, if that's the way to put it, from ours and more difficult to reconcile, and that is part of the mix. With that, Anthony?
Yeah, thank you, Fab. I think that, and Christina, first of all, it may surprise you. I would like to echo what Christina said about participation. I think it's absolutely crucial. We see Christina and we think, oh my God, they're incredibly organized. These people are just a phalanx of lawyers that it's terrifying. No one else is nearly as well organized, but they carry a lot of weight for the people that they represent. And it's funny what Fab is saying too, because of course my perspective is the opposite. The IP people, they just like waylay the board in the hallway and get whatever they want all the time, and nothing's ever finished because that's what's going to happen. So you can see that different groups are seeing the same thing from very different perspectives. One of the reasons to get involved in Icann, that it goes beyond what was talked about, is that it is a fundamental new way of governance that is global and transcends the usual structures that manage that. And it is, I think, quite consciously being put forward as a model for that by the US government and by European governments to do something about the lack of movement and the gridlock and the sort of the camps that are involved in things like the I2U and other UN type organizations. And the fact that even though for us it seems absolutely glacial, it actually is a more rapid policy development process that does bring more points of view to the fore. And I don't think that the ignoring the public, which has been the want of UN type organizations, is really very tenable going forward. So getting involved in this is really interesting from the perspective of where the world is going, not just the internet. So I would encourage anyone who has an interest in the world and how we're going to make it. This is really an experiment that is, although it's just kills me to say it because it's so painful, is really is really flowering in the world, and you see very major powers like the U.S. defend it in international forums where if this doesn't go well, it makes them look very stupid. So. I think it has a lot of legs and there's a lot of interest here. So I don't know if you put that in your report, but you might have.
Okay, Amy, before you go, you and I don't need to, this isn't the time or the place for a debate about the structure of Icann. It works well, but I do want to ask you a question just as a practical matter. How do you feel that you deal with the competing requests that come to you? Because you have them all the time. What's your process for dealing with it?
Well, at bottom, our process is to make them all deal with each other and really try to hammer out what the issues are. One of the, again, to echo the encouragement of involvement is key here, and that the idea of the model is to ensure that everybody does have a voice. And in order to be able to understand what the compromise is, we need to be able to understand everybody's voice as strongly as possible. The mechanism is a lot of public comment, a lot of involvement, a lot of meetings, a lot of discussions, a lot of working groups, and as Christina has indicated, it's a lot of work. But what the board wants to do, and what it strives to do, is to identify what can be deemed a consensus to a degree, compromise that everybody isn't compromising on everything, but they're compromising on some things so that the process can work, and to at least get a process in place and then take what we learn from that process and then encourage and enhance and improve based on different people's points of view. I know it sounds a little amorphous and it's hard to describe exactly how you come to that consensus. But eventually, and sometimes it takes longer than you hope, eventually you do reach a level where, and I don't know, in litigation, I was always taught that if you have a settlement, the best settlement was everybody walks away just a little bit unhappy, but not completely unhappy. And but there's a lot of happiness to be had because it comes to a point where at least they're achieving some level of what they are hoping to achieve. And that's what that's what the goal is in the Icann model. And that's why it is so important for everybody, to the extent absolutely possible, to get involved. Even if it's a little bit at the beginning, you might get really interested and want to get involved more.
Thank you all very much. Now we're ahead of time, I'm happy to say. So if there's anybody who has any questions at this late hour, we'd be glad to take them, or anybody. So I'm not expecting any, but if there are, step up. There we go. An unknown young man has a question.
From Ms. Stathos, this is a very specific question on a broad presentation. Christina mentioned that there were 12 public comment periods that are open. I want to just focus on one, and that is the one on closed generics, which is expiring on March 7th. And I can't remember now whether it was a 21-day or a 30-day period. First of all, is it Icann's position that this is a subject that has or has not been discussed as part of the DAG process? Because we're getting different views as to whether or not this has even come up in the past. And when I say closed generics, what I mean is if Amazon is awarded .book, can they close it off to its competitors, for example? That just being one of many companies that have applied for generic terms. Is this something that was considered as part of the DAG process, or is this a new issue that has come up?
We do know that there was a significant consideration of what some people would be a single registrant, single user process, but that was in significant relation to the brands, .brand type TLDs. We are actually in the process right now, pursuant to the board resolution that they took on February 2nd, doing a very thorough analysis of every single program, every single presentation, all of the email exchanges and the reports from all of the groups that were involved in the policy development process, in order to see if it was actually discussed in advance of the policy. I think, you know, people might have different views of that, but we are going to ensure that we're evaluating everything to see if there was any discussion had. In terms of once the policy was in place, we're also doing an evaluation after the policy to see if there was any discussions that were had. There were no discussions that led to a resolution or recommendation on a particular topic, but we are doing an analysis, and that should be done relatively soon in accordance with the same time frame as the public comment closing.
Well, in that instance, then, is Icann considering a reply period or an extension of the current period? This is a very difficult, complex issues. I mean, we have INTA, for example, has members on both sides of this issue. And if you've got some of the data that Mr. Vancouvering was talking about, shouldn't that then be made public and be part of the response from the public on during the comment period?
Right now, there is no intent for a reply period. It was a 30-day comment period that was open, I think, on the 6th or the 5th of March.
Well, I would encourage you to consider such a thing because it is, as I say, a complex issue. Certainly a lot of applicants made assumptions when they put in their applications, I am assuming, that the business models were going to be respected that were part of the application. So it's a difficult issue. I don't think 30 days when it was somewhat popped upon the public is sufficient. So I'd encourage a reply period at a minimum.
Thank you, and we'll certainly take that back, and rest assured that the board is taking this issue under serious consideration. Thank you.
Can I ask something real quick? Based on what we just heard here from Alan, it dawns on me that, and this is nothing to, it almost builds on Jonathan's questions of how do you balance competing interests and make the decision and kind of take this amorphous process of bottom up and come up with a hopefully somewhat right result. How are you going to balance the fact that the comment period will close on this subject, and you guys will obviously then have to digest that and go through GNSO and do studies, as I read the comment period, and come up with some sort of decision. But in the interim, the objection period is going to close. And what I anticipate, not based on any fact or anything from our company in particular, but from just hearing people, is that many people are going to try to object to closed generics. And so it's you end up with this kind of this is nothing new, right? You end up a little bit with a cart and horse, chicken and egg situation. In one instance, you may end up making a decision later that renders the objection moot, which is a dangerous place to be in when people from the public come in and pay down the range of $25,000 to $50,000 to object to something, and ultimately they're told, well, we decided it 2 months later anyway, and we're not giving you your money back, right? Or something to that extent. Or you guys decide something that later you change in policy. The objection is decided in some way and conflicts with your policy. How are you going to wrestle with that? Or is there any consideration, as Alan was saying, like extending things again? Or that wouldn't be anything new, but is that something that you guys are doing to, one of the considerations you're putting in is extending objection timelines on this, anticipating that people are going to object to exactly what you're trying to decide on?
At present, the objection period is closing on the 13th of March. It does go, in fact, to Jonathan's comment about how do you wrestle with the different competing interests, because you do have many people who are questioning and thinking about possibly objecting in relation to this issue, but you also have other people on the other side saying, don't continue it, make sure just go forward and press on. I will say, in terms of just the timeline, the filing fee is the only thing that needs to be paid on March 13th if the objection is being filed and there are proper grounds for that filing to be made. It's not until after the response and after the idea of how much it's going to cost that there will be an analysis and requirement to pay additional monies. So there will be some time in between when it's just the filing fee.
We're out of time. Okay, how much is it? 1 minute? Okay, 1 minute.
I just wanted to remark, since this is a group of people who might be interested, we have filed for 92 applications, including those of our clients who are using our back-end infrastructure, and we are now designing our Sunrise programs. And we have, as Christina's noted, there have been multiple sunrises. There's a lot of variations in what we can do for brand owners, and I would be very grateful for any input that anyone has in that. And if you'd like to know about what we're doing or what we're thinking of doing and offer suggestions,